Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. This is what I call my late breaking news video. I didn't intend on posting two videos today, but I have to do this one because I've just received some documents from an individual that's being sued in court. And here's the crazy thing about it. And this is why this is very important for me to get this information out to you. And I can say that I kind of blame myself a little bit for this because we have YouTube is a sharing platform, Facebook, these are all platforms to share information. But as I expected would happen and what uh, I've talked about potentially happening is that a debt collection lawyer has uh, made some serious adjustments to the way that we respond to the court summons. Not to say that this wouldn't have happened with YouTube, because it's going to also happen because we're actually submitting these documents and fighting against them in court. So I won't even say really YouTube had anything to do with it. It's just that maybe someone was on here and they kind of looked at how we were fighting. But to get into it, to be real quick, because I know you're busy and you got other stuff that you want to do. What they've done is that rather what we've always done is we've fought number one, the contract, show the relationship between the debt collection third party buyer and the individual that they're trying to sue to get the money. And it's been a hurdle, especially when it comes to certain judges, that they're like, if you don't prove that connection, other than the affidavits that you have, we need to have some specifically stating that individual's name on that contract. Because what they'll usually do is just give a pool of debt, and it won't have that individual's name. It'll just say this pool of debt, and then the court is taking a leap of faith, saying, okay, you showed the pool of debt that you purchased, you showed a document that shows that individual, but there was sometimes there was no connection. Some of the time the pool did connect. It would have a pool number and then a pool number on the some of the documents that would have the individual's name, but on some of them it didn't even have that connection. So obviously that was going to be thrown out of court. But what they've done on this one here specifically, what for what they're trying to do. Okay, so what they're doing is they're saying, okay, we see what you're doing to fight these court cases, and we didn't spend all of these thousands of dollars to lose. We spent these thousands of dollars to flip that over to make millions of dollars. And so we as attorneys, what we're going to do is we're going to make adjustments, which I've always talked about the making adjustments, but this one here is like a major adjustment. What they've done is rather than fighting it with the actual documents, they've stated what they would have or what they have. They've only stated, and then they said we're going to back it up with all of these individuals to testify. So if you want to win, we're already preparing to take this all the way to trial and either have a jury or a judge uh, question our people, or we question them. They're going to testify and say that you owe this debt. And so they have their whole long list. This is one that I haven't really seen happen. But the reason why they're making this adjustment is because they've been losing, and when they lose, they want to figure out the way to come back and win, and this is what they're doing. So, but there's a problem that I see with what they're doing, and I don't even mind saying this here on YouTube with this problem is that so they're saying that they'll have an individual testify, and we still don't know if these individuals that are going to be testifying are going to be with the original creditor or going to be with their company, but they're just throwing this list of people out there. But it's still, even if they say, okay, like it says here, it says we're going to have a itemized itemization of the account, running ledger, contract assignments, and any other documents supporting the claim. which the complaint is based on. So they're saying that all we're going to have all of that stuff. They're going to testify to it, but this is where I believe that they've made another mistake, and it's a mistake that really they cannot overcome unless the original creditor has made this adjustment, which I don't even think that they're allowed to do, but maybe they might do it. Is that they still have to submit all of the information. If you dispute, if you just say I dispute because I don't know, it's been a while, uh, I want to see everything, because if this is the original creditor, you could say, I want to see everything. They're saying that they're going to have testify to everything, but are they truly just testifying to what they have? This is what, and it could be just a few. You want all of the documents. If it's a credit card account, you want everything that you did from the day that you signed that contract all the way up to the day that the account went bad and you were not able to use it anymore. You have that right to push to get all of those documents. And they might come back and say, well, what are you disputing? If you want to ask me what I'm disputing all of it. I want to see all of it. If you're asking me this question, what am I disputing? Because you want to, because what they'll do is they'll say, well, what month do you dispute? What charge do you dispute? I dispute all of it. I dispute 100% of it, and I want you to get 100% of all of the documents, the charges, the credits, the payments, the interest rates that was charged, everything. And as a tip, why don't you get me my points that they're supposed to give me also, if you were supposed to give points? Another mistake that they made on here, and I don't feel comfortable saying this one, but I'm going to go ahead and say it because I want to share it with you just in case you're getting a summons like this one. Is that they actually put this statement in there. The defendant took and received services from the plaintiff and or plaintiff assigner for which the defendant has failed to pay. You never had a contract with the third party debt collector. You never took any services from the third party debt collector. Minimum, just because they made this mistake here, they would have to resubmit this whole document. That you could potentially get them to have to resubmit the whole document because you never took any services from them. And they're making an allegation right here that you took services from them. And then they say they took from the assigned party. Well, did you buy the debt or is it assigned? And if you're saying assigned, were you the buyer of the portfolio or was someone else? Because when they start to use those type of words, it was assigned. Was it assigned to you by someone else? And I'm going to thumb through here. And it says here on the assignment or the bill of sale from the original creditor. And here we go. This is why they said that. This is why they said that. Because this debt, okay, no, so it was sold to this particular uh, third party debt collector. It was sold to this third party debt collector, so there was no one that was in between that I see on here. Um, but it was you. They still never performed any services for what they did for what they are claiming on the debt. They never what they're claiming on their court summons complaint that they provided the service. They never provided the individual any services. The next thing here, affidavit of account by original creditor. Uh, process. Uh, Still only a pool on the affidavit of sale of account by original creditor. They did not fix the issue that they have with this document. It does not specifically state the individual and it does not state the actual pool of debt that they purchased. They could use this document with any debt that they purchased. And then the conformity. Conformity does not have any statement of the pool that was purchased. It only states that what they've done, it conforms, but it does not state the pool of debt, which they have to say acknowledge or proof of affidavits, does not state anything about the pool of debt that was purchased. And that's very important because if they're going to have this affidavit, they could just copy this and use it for every pool of debt that they've purchased. Something that I did see that was different than I've seen before is that they put, and I want to check this before I state it. Account number was not redacted. On this document here, the full account number was not redacted, which was another adjustment that they've started making. But I want to check something here. Yeah, full account number was not redacted. So that's another adjustment that they've made because remember in my summons responses, I've always asked to have a complete account number for your review. There are still a whole bunch of items that could be attacked with this debt collection uh, court summons. There's still a number of items that could be attacked, but we can see that they are making even further adjustments to, you know, I mean, if you were to get this summons and it's had here that you got, 10 people willing to testify that you owe this debt, I'm pretty sure a lot of individuals that would get that would kind of be kind of intimidated and say, okay, well, they're if they give them a call and they say it's you, and then they call another person you owe, another person you owe, another person you owe, that puts a lot of weight on that judge thinking that you might owe. So you gotta have your information to rebut what they're gonna say. And really the way to do that is what I stated earlier is that number one, you gotta break down, you gotta read how they put stuff together. And the number one things that I see with this one is that they made the mistakes where the pool is not shown on the affidavit. That affidavit could have been used for anything. They did not show if the original creditor filed a 1099-C. We would want to have that an affidavit or some document showing that that was not done. They made a mistake on here saying that that they actually provided the services, and the defendant never took any services from the third party debt collector. And there's some other things I'm not going to get into it on this one, but we're going to be helping this individual write their response, and we're going to have to see what the outcome will be. Uh, Ultimately, it's still going to be, up to the judge to make the determination. It could go either way, but you always got to lay all your cards on the table, and you got to see how it's going to come out. And I think that even with what they've done, there's still uh, good enough reason to either get it dismissed or a very good reason to get it placed for a very good settlement if something else was to come up to where the debt collector would say, hey, we might lose this, so why don't we approach this individual about doing a settlement? And let me see the amount that they're claiming on here. The amount, no, not even a huge amount on there, but they're going at it. All right, if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video what makes us different so you can see my 8-point validation process, my two-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com, and you get your TransUnion Equifax and Experian report, and that brings something up in my mind On your credit reports with the 1099-C, something that you need to look at is if it says that the original creditor canceled the debt, you can actually use that document when you do your responses to the court summons to state that this debt was potentially submitted with a 1099-C to the IRS, and you've already technically paid the debt because the IRS is going to consider it as income, and you got to pay taxes on that. A lot of people don't know that, and even some courts, from what I've seen, they like they're someone said that a court would not accept the 1099-C, and they have to accept the 1099-C because then they're actually penalizing you twice. The original creditor or another debt collector that had the debt before it, if they file a 1099-C, you do not have to pay that debt to them because you've already paid it. It's been discharged through the IRS with a 1099-C form. So, but you can see that on your credit reports. That's why it's very important to have a paid monitoring service because you will see that in the notes. If it says cancel, if it says the word cancel, connect that with cancellation of debt that could be filed and you could end up paying twice. A lot of people have gotten an IRS notification 6 months or a year later when it was filed and they had a debt collector also coming after them. So you want to check that. If you have a court summons, you can submit it to us to review it. Go to our website, thecreditrepairshop.com, go to the live chat, and then submit your documents for review. If it's a third party debt collector, this is the way that you can fight them by, making them produce documents. If it's the original creditor, if you don't dispute any amount on there, what you could do is get them to start talking about a settlement or possible 1099-C cancellation of debt if you have a true financial hardship that could be proven. And not all will accept it, but at least it's worth trying. And we've been able to get that done for clients who owe as much as $30,000-$40,000 to get those done. If you have debt collectors coming after you early in the game, grab my 3-pack of letters. Please make a donation on those because those letters can get debt collectors to stop coming after you for your money. And also the frustration, and it's just giving you a way to respond. A lot of people are just kind of shuffling. They don't know what way to respond. They're grabbing letters and stuff from other people that don't even interact with debt collectors. We interact with debt collectors on the phone, so we know what they're looking for, what they don't look for, what they don't want you to challenge, and what they don't care about you challenging. We deal with them every day here at our office. And then, so this is the end of the video. Please like the video. Please subscribe to the channel. Post your questions and comments. Thank you for your time. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.